Everyone assumes a set of car keys is the one thing that stays in your hand no matter what an officer says. That handing them over is always a choice, the same way answering a question is a choice. That belief is wrong, and it's wrong in a very specific, very costly way. In New South Wales alone, police impounded thousands of vehicles last year under a single set of laws most drivers have never read. And in a real number of those cases, the vehicle wasn't seized because of anything the driver said. It was seized because of what he did with his hand once 4 words were spoken through the window. So here's the real question this video answers. Does an Australian police officer asking for your keys actually carry the force of law? Or is it just another version of the phishing questions this channel has already picked apart? The honest answer is that it depends entirely on what's happened in the minutes before that hand goes out. And knowing the difference between a lawful seizure and an empty demand is the entire difference between a car you get back in 30 days and a car you never see registered in your name again. By the end of this video, you'll know the exact statute that gives police this power, the specific circumstances that have to exist before it applies, and the one sentence that gets the power named out loud without you making the single mistake that turns a seizure into a separate charge. Quick word before we get into it. No invented authority on this channel, just plain English Australian law, checked against the actual statutes, every section sitting in the description below. Let's start with where this power actually lives, because it isn't vague or discretionary the way some of the questions this channel has covered are. In New South Wales, Sections 148E and 148G of the Road Transport Act 2013 let a police officer confiscate the keys to a vehicle in specific circumstances, most commonly where the officer reasonably believes the driver is affected by alcohol or another drug to the point where continuing to drive would be dangerous, and the officer is stepping in to stop that from happening. Section 148 I then makes clear the keys can lawfully be retained until either the driver themselves or another person capable of exercising proper control of the vehicle comes to collect them. And even then, only once a police officer is satisfied that person is entitled to lawful possession of the car and capable of driving it safely. That's one doorway. The second, and the one behind most of the dramatic seizures you've probably seen filmed and posted online, is Australia's anti-Hoon legislation. Every state runs some version of it. In New South Wales, Sections 239 through 243 of the Road Transport Act give police the power to seize a vehicle on the spot for offenses like excessive speed, dangerous driving exhibitions, or repeated serious traffic offenses. The conduct, the law, and the public both call hooning. Victoria and the ACT run near-identical schemes. In the ACT specifically, police can seize a vehicle immediately if they catch a hooning offense happening, or within 10 days afterward if they reasonably believe the vehicle was used in one. Once seized, the vehicle doesn't just sit at the roadside. It gets moved to an impound yard, and getting it back involves a real process, not a phone call. Here's the detail that matters most if you're standing at the window when this happens. Section 241 doesn't just let police ask for your keys. It lets them take the car without your keys at all. If a driver or anyone else refuses to surrender them, the statute explicitly allows police to remove or neutralize the locking mechanism and start the vehicle by other means. Read that twice, because it's the single most important legal fact in this entire video. Refusing to hand over the keys, once a genuine power under Sections 148E, 148G, or the Hoon provisions has actually been triggered, does not stop the seizure. It only removes your car from that seizure with a working ignition intact. Now the mistakes, because they're specific to this exact moment, and they're not the same mistakes this channel has covered in earlier videos about questions and consent. Error 1. Treating the demand for keys the same way you'd treat a request to search, as something you can simply decline. A search generally needs your consent or independent grounds. The officer can be told no, and often has to build a separate case to proceed anyway. A properly triggered key seizure isn't asking for your permission at all. It's not a request wearing polite language. Believing it works the same way as declining a search is the single most common and most costly misunderstanding drivers bring to this exact moment. Error 2, and this is the one with real teeth: physically resisting. Closing your fist around the keys, pulling your hand back, locking the car with the officer standing at the door. None of that stops a lawful seizure, because Section 241 has already planned for exactly that outcome. What it does do is convert a civil, procedural seizure into a criminal one. Resisting or hindering a police officer carries its own separate charge in every state, on top of whatever the original Hoon or drink driving matter already was. You don't win the car back by holding onto the keys tighter. You just add a second charge to the file. Error 3. Assuming every request for keys is automatically lawful and handing them over without ever asking what triggered it. This is the opposite mistake, and it matters just as much. Not every officer who asks for your keys is exercising a genuine power under sections 148E, 148G, or the Hoon provisions. Sometimes it's simply an attempt to search the vehicle's boot or glove box more easily, dressed up as a keys request rather than a search request. And that version absolutely is something you can decline the same way this channel has already covered declining a search. Error 4. Staying silent about which situation you're actually in. The driver who says nothing at all, just hands the keys over or just refuses, has given the officer nothing to work with either way. And more importantly, has given himself no record of which power, if any, was actually named at the time. That distinction matters enormously 2 weeks later, when the question of whether the seizure was lawful gets decided somewhere other than the roadside. It's worth being specific about what actually counts as a Hoon offense, because the term gets thrown around loosely, and most drivers only have a vague sense of what triggers it. Under the New South Wales scheme, the conduct that opens the door to on-the-spot seizure includes things like exhibiting the vehicle's speed or power in a way that loses traction, burnouts, donuts, wheel spins, racing another vehicle on a public road, or repeated serious speeding offenses within a set period. It's not triggered by an ordinary speeding ticket on its own, and it's not triggered by a single moment of harsh acceleration that didn't lose traction or endanger anyone. The threshold is real conduct, observed or reasonably believed, not a vague sense that a driver was going too fast for someone's comfort. Knowing that distinction matters, because it's the difference between a stop where sections 239 through 243 are genuinely in play and a stop where an officer is testing whether you'll hand over your keys anyway without ever actually meeting that threshold. A word for whoever's sitting in the passenger seat when this happens, because the vehicle being seized affects more than just the person holding the keys. If you're a passenger and the vehicle you're in gets impounded, you don't carry any personal liability for the seizure itself unless you were the one driving or you're the registered owner. But you're also not entitled to demand the vehicle's release on someone else's behalf, and you have no independent legal standing to argue the power away at the roadside. The same phrase still applies if an officer turns to you specifically and asks you to hand over keys you don't hold or authority you don't have. I'm not the driver or the owner, officer. That's not something I can consent to or comply with. That's not obstruction. It's simply an accurate statement of who actually has authority over the vehicle in that moment. So here's the sentence, built to separate the two situations cleanly. Without you fighting a battle you were never going to win over a piece of metal. What power are you seizing my keys under, officer? I'll comply once you name it. Say it again, slower, because the second pass is the one that actually stays with you. What power are you seizing my keys under, officer? I'll comply once you name it. Every clause is doing a specific job. What power are you seizing my keys under puts the burden exactly where it belongs. Naming the statutory ground is the officer's job, under the same general duty this channel has already covered, not your job to guess at. I'll comply once you name it does two things at once. It tells the officer, calmly and on record, that you're not resisting, which matters enormously given what section 241 already allows if you were. And it makes clear that your compliance is conditional on a real power actually being named, not simply handed over the moment a hand goes out through the window, no questions asked. Picture the whole exchange, the version tied to a genuine power. Blue lights, you're stopped, and it becomes clear fairly quickly this isn't a routine check. Questions about how fast you were going, a description of what the officer just watched you do on the road behind him. Then, give me your keys. You, calm, hands still. What power are you seizing my keys under, officer? Section 239, Hoon provisions. That was a dangerous driving exhibition. Understood. I'll comply. You hand them over. Nothing in that exchange was defiance, and nothing in it was a fight you were going to win by holding on tighter. You got the power named, on the record, and complied with something that was always going to happen with or without your keys in your hand. Now the version where no real power exists at all. Same opening words, different situation. An ordinary license check, nothing suggesting a Hoon offense or an intoxicated driver, and the officer says, almost as an aside, just hand me your keys for a sec while I have a look in the boot. You, same calm tone, what power are you seizing my keys under, officer? A pause. Just want to check the boot, mate. That's a search. then. I don't consent to a search, but here's my license. This is the moment this video and the earlier one on vehicle searches meet directly. A vague request dressed as a keys demand is often simply a search request in different clothing, and the same non-consent this channel has already covered applies to it in full, because sections 148E, 148G, and the Hoon provisions were never actually triggered in the first place. The trained officer has two ways of pushing past a driver who asks the power to be named, and they're worth recognizing before you hear them for the first time on the road. The first wears impatience. I don't have time for this. Just give me the keys. You don't match the urgency. Same words, same level. I'll comply as soon as you name the power, officer. The second wears a threat dressed as information. You're just making this worse for yourself. It won't, and section 241 already tells you why. Your compliance was never the thing standing between the officer and the vehicle if a real power exists. Naming it costs him nothing if it's genuine, and costs you nothing to ask for. One more practical habit worth building into this exact moment, separate from anything said out loud. The instant a real power is named, whether it's section 148E, 148G, or one of the Hoon provisions, note the exact words used and the time, as close to that moment as you safely can, even if it's just spoken into your phone once you're clear of the stop. Officers are required to give a genuine reason when one exists, but memories fade fast, and the difference between section 239, dangerous driving exhibition, and a vaguer, unnamed justification given after the fact can matter enormously if the seizure is ever challenged. This isn't about distrust of the officer in front of you. It's about the same principle this channel has repeated in every video. Specific, checkable facts hold up in a way that a general impression of what happened never does. One last practical note, because what happens after the keys leave your hand matters as much as the moment itself. If your vehicle is seized under the Hoon provisions, New South Wales law requires written notice of the seizure to reach the registered owner within a set number of days, and the vehicle is typically held for around 30 days on a first offense, longer if there's a relevant prior finding within the preceding years, with a formal court process available to apply for early release or to contest the seizure entirely. If keys are confiscated under sections 148E or 148G because of a drink or drug-affected driving concern, the pathway back is different and generally faster. Return is available once a police officer has satisfied you or another properly entitled person can safely take control of the vehicle again. Knowing which doorway you actually went through changes what the next conversation with police or with a lawyer needs to be about. A genuine state-by-state note, because these powers don't sit in identical statutes everywhere. What you've heard tonight reflects New South Wales specifically, under the Road Transport Act 2013. Victoria runs its own anti-Hoon impoundment scheme with broadly similar seizure powers and its own timeframes. The ACT's Hoon laws, as you've heard, allow seizure on the spot or within 10 days of the alleged offense, with vehicles automatically released after 3 months for first-time offenders absent an extending court order. Queensland, South Australia, Western Australia, Tasmania, and the Northern Territory each run their own versions with their own section numbers and their own impoundment periods. The core distinction: a properly triggered legal power that keys can't stop, versus an ungrounded request wearing the same 4 words, holds everywhere. The specific timeframes and section numbers do not, so check the ones that apply where you actually drive. These laws didn't appear out of nowhere, and knowing why they exist changes how the moment feels when it happens to you. Anti-Hoon legislation swept across Australian states through the 2000s specifically because roadside warnings and fines weren't stopping repeat dangerous driving and impounding the actual vehicle. The thing making the offense physically possible proved far more effective than another notice in the mail. Local police data in some regions shows vehicles being impounded under these powers at a rate of roughly 1 a day, year after year, which gives you a sense of how routinely sections 239 through 243 actually get used, not as a rare, dramatic exception, but as a standard tool police reach for when the conduct genuinely meets the threshold. To close it out, "Give me your keys" is not automatically an order with the force of an entire statute behind it, and it's not automatically an empty request you can wave off either. It's one or the other, and the only way to know which is standing in front of you is to ask, calmly, before your hand does anything at all. If a real power exists, resisting only adds a charge to a seizure that was always going to happen. If one doesn't, the same non-consent this channel has already taught you applies in full. The sentence that separates the two costs you nothing to say and protects you either way. What power are you seizing my keys under? officer, and I'll comply once you name it. This is general information, not legal advice, and impoundment periods and section numbers shift at every state border. Check the ones that apply where you actually drive. If a seizure happens and you believe the power behind it wasn't genuine, the video ends and a lawyer begins. Legal aid exists in every state. Share this with the mate who's ever bragged about refusing to hand his keys over, thinking it was a stand worth taking. Tell me in the comments, did you know your car could legally be started without your keys at all? Subscribe for the next stop, because next time, it isn't your keys they're asking about, it's the phone in your pocket. That video's coming next.